welcome to Legal Wrangle. We have carefully selected 3 cases in this episode, one from the world of competition law, one from capital market, and most importantly, the landmark judgment of Delhi High Court in a copyright dispute between publishers and educational institutions. Let's start the program with a competition law case. This is a merger filing case where although the combination deal where minority stake was acquired was approved by the Commission, yet penalty was imposed. Let's understand why.
In 2013, SCM Solifert Limited, subsidiary of Deepak Fertilizer and Petrochemicals Corporation Limited, had acquired shares worth 24.4% in Mangalore Chemicals and Fertilizer Limited on Bombay Stock Exchange. The acquirers in its press release to the BSE mentioned that investment is very strategic and a good fit with the company's business. Later in 2014, SCM and DFPCL acquired another 0.8% in MCFL. These shares were kept in escrow accounts. Since this would have crossed the threshold of 25%, they made an open offer as per SEBI Takeover Code. SCM filed a notice disclosing detail of combination under subsection 2 of section 6 of the Competition Act with Commission within 29 days of the acquisition of shares.
The Commission approved the deal but was of the opinion that the initial round of investment did not qualify as solely for investment purpose or in the ordinary course of business to enjoy exemption under Schedule 1 of the combination regulations. In other words, the deal should have been notified as per section 6 subsection 2 of the Act. The Commission also found that the second leg of acquisition of 0.8% shares was notified after consummation of the deal, which violated the ex ante notification requirement under the Act. Penalty was imposed on the acquirers. The parties contended that the shares involved in the second round of acquisition were held in an escrow account till the permission from the Commission was obtained, and therefore the acquirers did not have any voting rights on such shares. The Commission observed that this was a contractual obligation self-imposed by the acquirers, and for legal purposes the deal already stood consummated. The parties appealed before the COMPAT, but the appeal was dismissed. The tribunal confirmed Commission's reasoning on all the issues, be it nature of investment, ex ante notification, escrow account, and the imposition of penalty. Just like the Commission, the tribunal also heavily relied on the press release issued by the acquirers as a vital piece of evidence to infer intention behind investment. The COMPAT held from the language of the press release, it is more than clear that acquisition was not solely for investment purpose. This press release eventually became the turning point of this case. Lastly, the COMPAT also clarified that for attracting penalty under section 6 subsection 2 read with section 43A, there is no need of any willful or deliberate breach and penalty can still be imposed.
So the COMPAT's decision in SCM Solifert has essentially endorsed the very restrictive approach that the Competition Commission of India has been taking of minority investments. So what this means for an investing company is that howsoever small the investment is, even if it is less than 10%, they have to be very cautious if they are acquiring any affirmative rights as a result of that investment, or if that investment is what the CCI can term as strategic investment, or if they are appointing a member in the board of directors. So in all these situations, the best approach for any company to adopt is to take a good legal counsel to ensure that they are not acting against the provisions of the Competition Act. Insofar as the relevance of willful default for the imposition of penalty is concerned, it becomes a little more important in this case, because in this case what the parties were essentially claiming was that by virtue of a CCI regulation, they were not required to make a filing. So in such a situation where the regulator has itself created a regulation saying that in certain cases you do not need to approach the Commission to take an approval, the element of neglect or willful default becomes very, very important. Also, the COMPAT, in the only other order that they passed in combination cases, which was the Thomas Cook matter,
had actually lifted the penalty on the ground that there was no bad intention, no mala fide intention on the part of Thomas Cook. So some amount of consistency, I believe, should be there in the approach adopted by the COMPAT as well.
Students call it fair, but publishers unfair. Yes, we are talking about the recent landmark Delhi High Court judgment over the use of course packs by Delhi University, which has generated lot of news and noise.
Course packs are nothing but reading from different authors accepted and presented to students. But no one would have anticipated that this would ever result in a big tussle. Rameshwari Photocopy Service, defendant number 1, ran a photocopy shop from the premises of Delhi School of Economics. The defendant photocopied extract from the plaintiff's publications and compiled them into course packs for sale to students. The course packs was based on syllabi prescribed by the university. This was done to help students avoid buying lengthy and costly books and yet learn from different sources. 5 stalwarts of publishing industry, which included names like Oxford University Press, Cambridge University Press, collectively filed a suit for permanent injunction and damages against the photocopy shop and Delhi University for violation of their copyrighted books.
The limited issue before the judge was whether the copying of excerpts from books for the purpose of creating and disseminating course packs comes within the exceptions of Section 52 of the Copyright Act. The Delhi High Court observed that such course packs, to enjoy protection against infringement of copyrights, the action of reproduction of such work has to be by a teacher or a pupil in the course of instruction as per Section 52. The court held that while the expression used in the section is by a teacher or a pupil, but it has to be construed in a wider sense to include an institution imparting education and not be limited to an individual teacher. Similarly, the words in the course of instruction should not be limited to only classroom instruction, but must include that preparation which both the teacher and student are required to before and after the lecture. For the time being, it is a big victory for the educational institutions, but the publishers have already filed an appeal before the Supreme Court.
The kind of broad interpretation that we have given to the fair dealing provisions of the Indian Copyright Act may not do justice to the specific language of the statute itself and to the fairly limited language of the statute itself. And I think perhaps the decision has resulted in creating an extremely subjective landmine or a landscape wherein it may now be possible for everyone to willy-nilly infringe and infract copyrighted work, citing educational use or for the purposes of instruction or for the purposes of education, and giving it the broadest possible interpretation, thereby effectively undermining a right which has been recognized, all in the name of perhaps public interest, which I think may send out a very wrong message. I also believe that it ends up reinforcing the stereotype that India perhaps does not accord intellectual property rights the same value and respect as mature IP jurisdictions.
SAT comes to rescue of country's top short merchant bankers. Yes, the merchant bankers took a big sigh of relief when the Securities Appellate Tribunal, by its majority order, quashed a decision of the SEBI where it had imposed penalty on them. The issue was regarding non-disclosure of certain information in the red herring prospectus during the IPO of Care Limited.
Care Limited had appointed Kotak Mahindra, DSP Merrill Lynch, Edelweiss, ICICI Securities, IDBI Capital Markets and SBI Capital Markets as book running lead managers for its IPO. In the DRHP, it was proposed to offer the share through IPO to eligible non-residents covered under Schedule 1 of FEMA 20 regulations and also to non-residents covered under various other schedules. For issuance of share to non-resident under Schedule 1, CARE was required to comply with the minimum capital requirement norms prescribed by RBI. In the meantime, RBI issued a circular which permitted transfer of shares from resident to non-resident without RBI approval, provided a NOC was obtained from the regulators of the non-resident investors.
CARE obtained an exemption from RBI on the NOC requirement subject to certain conditions, and then the subscription opened. But thereafter, RBI insisted CARE to comply with the minimum capital requirement norms, although there were no non-resident investors under Schedule 1 in the IPO. CARE did the needful. Later on, SEBI issued a show cause notice to the merchant bankers for failing to disclose material facts in the prospectus. SEBI was of the opinion that the investors were misled to an impression that RBI had granted an unconditional exemption to CARE. Penalty was also imposed on the merchant bankers. The matter went in appeal before the SAT. SAT observed that when ICDR regulations and merchant bankers regulations specifically provide that offer document shall contain all material disclosures which are true and adequate for enabling applicants to take an informed investment decision. Therefore, SEBI was not justified in holding that appellants ought to have ensured disclosure of information relating to compliance of minimum capitalization norms, even if the said norms were not applicable to the non-residents who were permitted to participate in the offer of CARE. RBI directed CARE to apply minimum capitalization norms in relation to investments by NRIs, and CARE agreed to comply with the said direction. And this cannot be inferred that RBI had directed CARE to apply minimum capitalization norms in relation to investments by non-resident investors covered under Schedule 2 and 8. Well, this brings us to the end of this episode of Legal Wrangle. Please write to us at editor@tioltube.com for detailed analysis of these and more interesting cases on corporate law matters. Please subscribe to tiolcorplaws.com. Thank you for watching.